Hello, everybody. For those of you that have been watching this show for the last couple of years, you know the kind of topics that we typically bring up, and they always have to do with people that own businesses or work in larger companies. And today we're going to talk about some of the hidden traps that business owners can step in without even knowing what's going on, and all of a sudden invite unwanted litigation that could end up being very costly. So we're going to walk you through that, and we've got a special guest today that's going to help us do the same so that you know exactly what to look for, and hopefully you can avoid those catastrophes. Stay with us. Okay, welcome. This is the Business Wingman Show. I am Steve Smith, one of your co-hosts. Travis Smith is our other co-host. And today we have a gentleman who is in the business attorney field. His name is John Newell, and he works for Shell Nuelle LLP. He is a guy that specializes in corporate issues and general litigation. He's got a wide berth of knowledge in everything that has to do with businesses and being sued and what you do with them. So, John, thanks for being with us.
Steve, appreciate it.
All right, so let's start off by just give us a little background. You don't have to go into any excruciating detail, but just so everybody knows kind of where you're coming from.
Sure, absolutely. So I've been an attorney for approximately 26 years, roughly, give or take. Currently, and what I've been doing for the last 6, 7 years really is focusing on business clients. And I would say probably about 70% of my clients right now are businesses, sole proprietors, corporations, something of that nature. And what we do is we really help our business clients in the sense of, we do everything from startup to shut down, everything in between, whether it's litigation, corporate contracts, employment, anything that might affect or touch a business, we handle those types of things. Obviously, tax and some of those other things are different, but that's kind of the focus of my practice now. And like I said, I've been doing this a long time, and I cut my teeth in general litigation way back in the day, and so I started as a litigator, litigating anything from might have been a personal injury, a business dispute, wrongful death, those types of things. And ultimately, my career kind of progressed over time, where I went into things like professional responsibility, malpractice type suits, representing physicians, attorneys, brokers, those types of things in more of a business setting. And ultimately, it transitioned, and I began to get more business clients along the way before I ended up going in-house. And I was in-house for a period of approximately 7 years. So I was in the corporate landscape in that, where and it was a big healthcare corporation. So I handled a lot of various different things, including, I was involved in risk management. I was involved in compliance. I still did litigation, but I also did a lot of corporate stuff too, contracting, purchases, things that involved the day-to-day operations of a business, handling employees and those types of things. And ultimately, I am where I am now. So it's, I started in the litigation, moved into the corporate a little bit, and now it's a bit of both.
Nice. Well, listen, start off by telling us, when you get contacted by people to help you through a legal matter or maybe even potentially represent you, what are some of the biggest overriding things that small business owners end up being threatened with some type of litigation over?
Sure. There's a number of areas, right? And we can kind of get into some of these things, but there's a number of areas. Obviously, once you have employees, that's a big part of it, right? In employees, there's a lot of traps and there's a lot of potential issues in dealing with employees and how you handle those situations. The other is really from the onset, how do you set yourself up, right? Do you have a business partner? Is there another owner involved in it? Do you have the appropriate agreements? Because everything's great at the beginning, right? But you got to plan for the worst, because there are definitely disputes and things that occur over that time. Then obviously there's other things related to contracting, dealing with vendors, vendor suits, and so forth, related to those various types of things. Those are kind of I would say, the biggest areas that I see in this. And it's funny because people will call me, or I'm dealing with a client, and one of their first or questions of me a lot of times is, okay, if we do it this way or we handle it this way, will that prevent me from being sued? And I always tell everybody, nothing you do could prevent you from being sued, because people sue for all sorts of different reasons, right? It doesn't mean you're not going to win, right? It doesn't mean that you're not going to win, but there's always a potential of a lawsuit. What you're trying to do as a business owner is set yourself up to, one, protect yourself as best you can in those situations, or if you happen to be on the other side as a claimant or a plaintiff, to set yourself up to potentially win and argue your case. It's the risk management versus putting yourself in an advantageous position.
Right. Well, okay. So one of the things I've always been interested in is when you get contact, there's an issue or somebody's registered some complaint that looks like it's going in that direction. What percentage of these things end up making it all the way to litigation? And if it doesn't, what usually happens along the way that keeps it from being some courtroom drama?
So I would say the majority of claims or cases or disputes or whatever it may be, they resolve before in one way or the other, whether it's a settlement, someone walks away, or so forth. It's a very, very small percentage of cases that actually make it to a jury trial or a court trial. It's probably 1% of all cases that ultimately are filed with the courts make it to trial. Obviously, if in order to prevent even getting to that part where a lawsuit is filed, you're trying to set yourself up, with pre-litigation procedures, whether it's a mediation, it's a dispute resolution, it's something related thereto to prevent that. And the clients that have those procedures or that are engaged early with a potential claim or a potential dispute have a less likely chance to ultimately end up in court, because nobody wants to end up in court, right?
Right.
For these things. And so I don't know if I can give you an exact percentage of how many actually end up in litigation. It really kind of varies, depending on the clients and how things are set up. Sometimes you can't prevent it. Sometimes it's just that's the way it's going to go.
But it sounds kind of like that's the minority of things. The far greater chance that something's going to happen before it ever gets to that point to where the parties agree.
Right. There's opportunities. Right. There's opportunities for a resolution or some type of something that you can do to limit the chance that it's actually going to get filed, that a complaint's going to get filed. Sometimes you can't do it. Right. It ultimately ends up in litigation, but the goal is to try to resolve it or to try to minimize it before it gets to that point.
Well, John, in this discussion where we're talking about ways to reduce our risk, right? In particular, and then you brought up hiring employees. And one of the things that I think is so important, I would love to get your thoughts on this, is the importance of an employment application through that process. And then within that application, having a dispute resolution agreement in that. So can you talk with us about why someone as a business owner would need an employment application process? And then for those who are listening who don't know what a dispute resolution agreement is, what is it? And then why is it important to incorporate in that process?
The application process, it's kind of twofold, right? It's the initial part of you're reaching out, you're trying to hire someone, you want to understand what they are, you want to understand their background, you want to see these different things. There's also the aspect of when they're in the hiring process, when you've decided to bring them in, what's your new hire packet? What are the different agreements that you have in there regarding also dispute resolution, those types of things, right? And it's extremely important that you're getting as much information about potential employees as possible so that you can make an informed decision as to whether or not this is the right fit, right? Whether or not they have the experience, whether or not it fits your culture of your company and those types of things. So these are the processes that you can actually weed out potential negative employees or individuals that aren't going to fit that, right? And so it's not just, okay, I like this individual, I'm going to bring them in, I'm going to hire them. No, you want to understand, you want their background information, you want to see where they've worked, you want to call references, you want to explore every potential option that you can, obviously under the law, to vet these people, right? We don't want to go outside and start doing things that we shouldn't do, but you want to vet them as much as possible. Now, when you get into the hiring process, you should have, as a business, a new hire packet, right? You should have something that you are presenting to these employees at the outset, that they are filling out, that they are signing, that they are agreeing to as part of their employment. And when we talk about dispute resolution, we talk about arbitration agreements, right? Mediation provisions. And for people that aren't familiar with that, that's mediation is essentially, it's you sit down, you try to resolve it. Usually there's a neutral party. It's a retired judge, or it might be an attorney who mediates the thing to try to reach a resolution. They have no stake in it at that point. They're just trying to reach a resolution as part of it. If that's included in your provisions, it's some type of, hey, you got to go to mediation before you can file a lawsuit or something like that. It gives the opportunity to reduce or try to resolve the potential issue ahead of time. Now, arbitration agreements, we see a lot of those in the employment context, where essentially you're agreeing as an employee and the employer to an alternative venue for your dispute. You don't go to court. Now, there's, California obviously has some rules and some regulations relative to what can be arbitrated, what can't be arbitrated on these things. But if you have the arbitration provision, it's not in your typical, superior court or federal court or whatever it may be. You are actually just bringing your case before another neutral. It's usually, again, a retired judge or an attorney, and they ultimately are the ones that are deciding the issues of the case and ultimately giving a ruling, essentially a judgment, right? Who's going to win the case,
right?
There's pros and cons of each. Obviously, with arbitration, you got to pay for it. And in the employer-employee context, a lot of times that falls directly on the employer to fund these things, and they can be more expensive, but normally the process is much more streamlined. There's restrictions on what you can do, what you can't do as far as discovery and those types of processes. But it's those are important aspects of your pre-hire process or your hiring process in order to get these things in and make sure that you're protecting yourself as an employer.
I think a part of that too, to really think through as a business owner, is if you have somebody that pushes back on you as to signing a application, or that really should be a giant red flag.
Absolutely.
This is the point where being emotionally involved, in hiring someone, you really got to pull back on that, because if someone's not willing to furnish references, this is another one that I've come across before where, I just don't remember the name of the person that I worked for, or they don't work
for 8 years.
but it was only like 5 or 6 years ago. I was like, I'm certainly nobody special. I could tell you the name of every single person that has ever been a boss for me for the last 20 years. So if you can't even remember the last 5,
there's red flags, right? And that's, your spidey sense goes up or whatever it is as an employer and as a business. What are they pushing back on? What are they refusing to sign? Now, when we talk about the dispute resolution type things, those are generally provided to you at the time of hire and as a condition of your hire. Now, if you're a business and you don't have one, right, you can ask your current employees to sign an arbitration agreement, but you can't force them to do it. And so, obviously, there's things that you want as a business, and you can make the corrections, right? If you're not doing things that you're supposed to be doing, or you need more, you could always make those corrections. It's not too late. it's not too late to try or to do this. But obviously the goal with the business is setting it up the right way to start so that you're protected from the onset on this. Yeah. And you like you hit the nail on the head with, if there's red flags, there's, I don't know how many times. Yeah. I don't know how many times I've had, clients tell me, yeah, I had a bad feeling right off the bat with this person. I'm like, well, why'd you hire this person? Right. That's why you're in this lawsuit. So yeah, trust your gut.
All right. So, hey, let me go back to something you said earlier about when you first talked to a potential client on the phone. Mm-hmm. Obviously they're coming, seeking legal help for something that they've gotten themselves into. Once you get into the details of what's going on and maybe how it all transpired, in the back of my head, I'm thinking, is this an area that the business owner was completely ignorant on? They just didn't know. Okay. Or did they know that this was something that might crop up, but they just chose to ignore it? Where do you find people tend to fall into one of those two camps? What?
Yeah, there's one thing about, that I found with running a business, and I run my own business too, right? Is sometimes you don't know what you don't know what you don't know, right? On these things. And sometimes you come into it and you're like, I had no idea. I didn't know I was supposed to be doing these things, right? And that falls into one bucket, like you said. And the other one may be, well, yeah, I should have known better. I knew that, I should have had this agreement, or I should have done these checks and balances and so forth. And it didn't, and now I'm in this situation, help me get out of this situation. So it kind of falls into two buckets. And yeah, it's, when I generally talk to a client first, there's those two buckets, but it's kind of split before that. They usually reach out to me, one, because they're trying to set it up or do things right or get a contract or those types of things, or they're already deep in it, right? With some type of claim or some type of litigation.
Right.
And then we're trying to dig them out.
Huh. What? Go ahead, Travis.
Well, John, when you get a call from someone, like you just said, and you can already kind of feel like whatever has happened, right? And now it's like everybody's trying to figure out how to get your client out of the situation, right? Can you maybe share with us what are things you've experienced in that moment where your own customer actually made the situation worse?
Yeah, they do things a lot of times to actually make things worse. And I can tell you, I guess what pops to mind is you may have an employment issue with an employee, right? Who's negative, who's caused all sorts of problems and everything else. And there's a dispute. There's headbutting between the employer and the employee. And if I had been involved just maybe a few days earlier, we could have worked it out and potentially worked on a resolution to terminate the employee, or worked on a plan, how to do it, or whatever it is. But then they call me and they'll say, yeah, I had this dispute with this employee, and then I fired him. And oh yeah, by the way, they just told me they're pregnant. And I'm like, what, you just made the situation so much worse, right? Because obviously, you can't fire someone because they're pregnant, and they didn't necessarily fire them because they got pregnant at the time, but it looks bad, right? It's a situation where you had a dispute between the parties, and ultimately the person was going to need to be terminated, but you had to do it the right way. And instead of just off the cuff, you're fired, you're done. Oh, by the way, they told me, 3 days earlier that they were pregnant. And it's those types of situations where I just, I put my head in my hands and I'm like, okay, well now it's gotten potentially even worse on these things. Or, in a contract sense, they sign a contract that they know they needed to have reviewed. They didn't like some of the terms. Now they're disputing the terms. And it's like, well, why didn't you contact me ahead of time? Because now you have to pay me more to help get you out of these things, in this potential dispute.
So, all right. So when it comes to those early phases of an owner either knowing that they messed up or something's happened that's going to cause them to have to address it legally. How much, I mean, you know, look, AI has gotten into everything, you know, and it's not stopped. It's on a growth curve. But when it comes to what you do and what people do before they come to you, how many times do you think people are using AI to try to solve a legal problem when they're not an attorney themselves?
The time.
What?
All the time. I see it more and more. And what I'm seeing a lot of is people are using AI to create contracts. They're using it more, you know, they're using Chat GPT and to create a contract. And, you know, I won't name the client, but, you know, recently I had someone present me and said, hey, you know, I need to talk to you about this contract. And I get it. And I look at it and I'm like, who wrote this? And he's like, Chat GPT. I'm like, well, you're missing a whole bunch of stuff, right? Chat GPT is fine for maybe a basic outline. I always tell people don't use it, you know, for your legal documents, but there's a lot more that needs to go into it. But I'm seeing, you know, individuals use AI to, you know, they'll write letters, they'll write dispute letters, they'll try to write contracts with Chat GPT and in these types of things where, yeah, there may be some parts that are okay, but generally, when I get those contracts, there's a ton of stuff that's left out. And, you know, we're seeing that, you know, AI is the wave of the future, right? It's coming. And
Right.
we actually use it in our legal stuff as well now. You know, it's coming, and it's how to manage that and make sure that you're not bringing something in that isn't correct. Because we've seen that before where, you know, there's sites to maybe it's codes or lawsuits or, you know, litigation or opinions that aren't valid. They don't exist. You know, that particular case never existed. Right. But there's a site to it within a particular document. And so you really have to be careful with that type of stuff. And, you know, I'm not telling people you can't use it, you know, right? But just understand and be cautious on how you use the AI. You know, it's still obviously better if you can get a legal, you know, review of the thing to make sure that you hit all the buttons on it.
Well, you know, John, in this discussion we're having right now about the contract side of businesses, can you maybe help us understand why is it today people still get into partnerships, full-blown businesses in particular with other people, and it's done on a handshake agreement?
I can't explain why they do it, but it still definitely happens, right? And what, you know, my perception and kind of what I've seen with it, right, is let's say it's two buddies, you know, and they're good friends and they want to start a business and they're like, let's start a business together. Yeah, 50-50, we'll split it, you know, let's set it up. And it's fine at the beginning, right? Because everything is good to go. You know, you're maybe money's coming in, you know, you're agreeing on everything, the business is doing well, and everything's okay. But at some point, you know, I'm not saying in every circumstance, but there tends to be some argument on the direction of the business, or more likely is one business owner not doing as much as the other business owner. Right. And the other business owner feels like, well, I'm doing everything for this business. I should be entitled to more. They should be entitled to less. And you know what? I'm going to pay them less. Well, you can't do that without an agreement, right? You have to, and that's where a lot of times you get into these disputes, right? With business owners, you have one suing the other one, and whether it's a handshake agreement or it's just simply, you know, written on a napkin or, you know, or whatever it might be, right? It just doesn't have the detail that you need. And when I talk to people about formation and forming your business, and if you have partners, if you have more than one owner of the business, you're always looking at the worst case scenario, right? You always look at, okay, what's our buy sell? What's our dispute resolution? How do we handle a dispute? And what are the options for ultimately buying someone out or selling shares or however it may be, right? And I tell people it's never too late. to get those agreements in place, and it's better to do them when you still have a good business relationship with your partner, or the co-owners, or whoever it may be. It's never too late to do that stuff. Obviously, it's better to do it in the beginning, but yeah, you as a business owner, you're setting yourself up for problems if you don't have the appropriate written documentation for how the business is handled and how what happens in case of a dispute or an issue.
Yeah,
So
I had somebody explain it to me as similar to a prenup.
Yes.
oh yeah,
And yes, while they're not exactly one and the same, the reality is when you're going into a partnership with another person for purposes of business, it kind of is a marriage.
It is.
Two people
Yeah.
are coming together with assets of some kind, right? And so I know for whatever reason, prenups tend to have a little bit of a black eye in terms of the usage for that. But at the same time, to your point, how important it is to establish policies up front where, hey, if we have a disagreement, what's the process we're going to drill down on to come to a conclusion so the business can continue to move forward?
Exactly. Yeah. And sometimes it's a difficult conversation, especially when you have friends and they're good buddies, or whoever it may be. And it's like, hey, well, if we disagree down the road, this is how we're going to proceed. It's like, well, we'll never disagree. We're great friends. We're going to be just fine. We don't need this stuff. Well,
right.
I don't know how many times I've seen really good friends on, both on opposite sides of the case suing each other because, they had a disagreement, or there was, an issue with, again, how much someone's doing or contributing or whatever it may be.
All right. So for a business owner that's fairly early into the formation of their business, actually starting it up, getting it running, we're talking maybe 12, 18 months in. Um, is there a way, or do you offer such a service, almost like an evaluation that you can run a business owner through based on the kind of business that they're running, that can kind of checklist the things they need to be doing early on to insulate themselves as much as possible from legal action?
We do, and it starts with the formation process, right? And it's what type of entity do you want to be, or what you can be, because there are restrictions on. If you're in a certain profession, you can't be an LLC, or you have to be a corporation, or whatever it may, or you have the choice of a partnership.
Right.
So it's part of obviously filing your appropriate documents with the state, but also getting, whether it's your operating agreement and your bylaws or whatever else it is, get that set so you have those documents. You can always amend them. You can always change these things, right? And then the question becomes, all right, well, are you hiring employees? What are you going to do with the aspect of employees? And it's kind of, it's when I sit down with people, I ask them about their business. What are they doing? And then, I offer them my opinion as to how I think things should go. And ultimately it's up to their decision, right? Whether they want these various things, but it's a checklist of, okay, maybe you're in construction and you're a general contractor. Well, your contracts, you're going to need those contracts right up front, and those have to comply with the contractor state licensing board. There's certain requirements. So are you compliant with those types of things? So it's kind of an industry specific in how we set it up. But obviously there's general things that we do for each business on it. It's the setup, it's the whether you have an employees or those types of things. And then if you're offering a service and you're going to do contracts with people, well, what do your contracts need to say? What is the specific language? What are your obligations with the state? What are your legal requirements? And so it's kind of a couple different steps to get to them to the point where they can feel comfortable that I can go out, promote my business, sign clients, do work, and feel protected, right? And like I said, at the end of the day, you could still be sued for anything, right? But you're more protected at that point in time, and you can feel comfortable offering what you do.
Well, okay, so here's a good example, and it's one that many, many years ago, I think, was just being abused. I don't hear too much about it anymore. It's the whole ADA compliance thing, okay? let's say you have a guy that owns a facility, a building that his business is in, and he's owned it for a long time, and maybe he's been grandfathered on certain things about the building because that's the way it was when he started, right?
Right.
And he decides he wants to get out. So one of his key employees has decided, you know what, I've always liked this business. I think I can run it if I can come up with the money. Do we have a deal? So they do a deal. The former owner sells the business to the employee who's been an employee of that company the whole time. So it basically is just an owner name change. Does that cause the new owner to have to make good on any ADA things that might have been grandfathered under the old guy, but now that there's a new person running it, it's like, okay, you got to be compliant with everything based on today.
Generally, if you're a business and it's just a change of owner in the business is generally, the business is going to continue on, right? And I'm not saying that there won't be situations where all of a sudden you lose your grandfather rights on these things, but in general, if the business is still just operating as the business without changing, it doesn't change from a corporation to an LLC. It doesn't have name change. Doesn't do certain things. You're generally going to be okay on the safe side, right? On these things. When you start changing entities, or it's another business buying that business, and then converting it or whatever it is, then you may have potential claims, right?
Mm.
And the ADA stuff still exists. It's
Oh,
still
I'm sure it does.
it's big business out there for some firms. And one of the things that we see, we don't see the as many of the access issues anymore with people not having the correct spacing in the bathroom, or the doors aren't wide enough. We don't see as many of those. The ones that we are seeing are the website issues, and it's whether or not your website is ADA compliant. And it generally has to do with people that have, they're either blind or they don't see well, right? And those seem to be the more prominent ones that we're seeing with
Okay.
regard to the website. And I know, we've had some cases where, we pulled up the plaintiff information, and, they filed 300 cases. And it's just,
Wow.
they're just, I'm not going to say it's, I'll just say they're filing 300 cases. You could take what you want from it,
Right.
and
Right.
it's the same pattern, same fact pattern, and so forth. And they just target websites.
So, John, I hear very few people talk about that subject. So, can you walk us through maybe just big picture
Mm-hmm.
to be ADA compliant with a website? So, again, to be clear, we're not talking about a ramp to get into your front door of your
Right.
building.
Right.
We're talking
Right.
about an online website. Big picture, what are we looking at here?
Yeah, basically what it is, and I'm not a tech guy, right? But it has to do with the ability for someone that, if you're offering and serve, let's say you're a pizza joint, right? And you're selling, food online, and you can order online, and you can do those types of things online, right? Can someone who is blind, or has a hard time seeing, access and use those services on your website, right? Is there a reader where, if they are, they plug it in and they can hear and scroll over the different things to access those types of things, right? And there are, you can check. I believe there's actually free, don't quote me on it, but I believe there's a free service where you can actually check to see if your website is compliant as far as ADA stuff goes. Don't quote me on it, but if I recall on that, there should be something like that. But it's really, in California, obviously has a list of different things that you have to do to be compliant. You can access through the state and so forth. But really, it gets down to, can someone who has difficulty seeing or is blind, can they access your website if there's a service being provided?
So, I mean, when we get down to all of this, when you start thinking about the points of legal issues, where they're coming from, it could be clients. It could be people that aren't clients but are just looking at your business, because they're trying to learn something. in that situation. It could be vendors that you're considering doing business with or already have done business with. It could be employees. It could be partners or other people of a financially vested interest in your business. So, I mean, it's like circling the wagons and you standing in the middle and everybody's pointing inward.
We all know California is a difficult state to be a business owner in, and it's definitely set up as far as the liability goes that it's
First time I've ever heard that, John.
Right. It's really easy to start a business in California, but once you get going, obviously there's a lot of potential issues that you have to deal with, as on various aspects, right? Not just the employee aspect, the ADA, all of these various things, and yeah, it's a situation where you may be great at what you do, as a business owner. Your service may be impeccable, but if you don't know how to protect yourself or manage these things, you can be the best in the business on what you do, but you could set yourself up for all sorts of different liabilities and all sorts of different problems that ultimately cause you to close your business. And so it's, like you said, there's so many different things that can point at you. And I like to tell my clients a lot of times, the ones that are, when they get sued for the first time, I say, look, when you start doing well as a business, when you start doing well as a business, you're doing really well when you get sued for the first time, right? It's like, okay, here it comes. And, obviously the bigger you get and the more involved you are, the more employees you have, the more contracts you enter into, the more of those things, the chances obviously of having potential disputes, it just happens.
So I want to hit on one topic here real quick, because selfishly on my end, I've been through this and I would just love your perspective on it. And I had teased this out before we started our discussion here today. EPLI insurance. All right. I'm amazed, John, at how many business owners, they've never even heard that acronym, let alone understand it's important in their business. Can you maybe just educate us all on why should a business owner consider that insurance if they own a business in California?
So let's talk insurance in general first, right? As a business owner, normally you're looking at, you need to get insurance for your business, but what do you need to get, right? Most people have a general liability insurance that includes certain things. It might include copyright or trademark. If you don't have them, take a look on those things. You might have your workers' comp insurance. You also might have directors and officers insurance as well, depending on how big your corporation. But the EPLI insurance is really related more to the worker themselves and issues related to wage and hour, overtime issues, typical things that you might see in an employee-employer action on these things that aren't covered under your general policies, right? And when I talk about wage and hour and I talk about kind of this overtime issue, it's a huge area of litigation in California. And it has to do with not paying the person the correct amount. You don't pay them the correct overtime. Maybe they don't get a meal break. Maybe they don't get their typical breaks and so forth. Typically, those types of claims are not covered under a typical insurance, right? Your GL policies in those types of things. You need a special line of insurance to cover those things. And when you do have it, when those claims come in, a lot of times, the insurance carrier picks up and they cover the cost, not just of the defense, but of any potential liability as well. And I have unfortunately, had a couple clients that actually had to close their business because of wage hour type of issues, where it was more than the claims, along with the attorney's fees and everything else that's related to those particular claims. They couldn't afford to resolve it. Wow. And they didn't have the particular insurance. And as a result, they had to close their business. One went bankrupt, and so forth, because and for those that don't know, in employment claims, generally in California, the plaintiff's attorney's fees are included as part of damages. And that's where you get a significant increase in the potential liability. So you may have an individual or an employee that you forgot to pay, right? Or you messed up on their overtime, you messed up on something, and the real cost of it may be $5,000 to $10,000, right? To make it right. But if there's litigation and there's a lawsuit and they've retained an attorney, all of a sudden that $15,000 might go to $115,000 because of the attorney's fees, and they're statutory, they're required. So those are the type of situations that you can get into as a business owner that can definitely cause problems. And the EPLI insurance is supposed to help cover that. Don't quote me on this, I'm not an insurance broker, but it tends to be a little more expensive than your typical GL and workers' comp type policies. But obviously, if you're a business and you have a lot of employees, and especially hourly employees, it may be something for you to look into.
So I had asked that question earlier because I've been through this road, and your comment earlier, John, about hey, once you get your first lawsuit, you're a real business.
Mm-hmm.
I will candidly admit the following. One, so glad I had EPLI when that happened, despite my position that it was a complete fraudulent experience. But such is life, right? This is part of business. That said, what are some things people can do along the way when they have that employer-employee engagement, maybe to kind of hedge their bets on that end, right? 'Cause, you've brought up a couple things here that are pretty standard in operating a business, running payroll, right? Making sure meal breaks are occurring. So what are some practices that employers, especially small businesses, can put into place to make sure those areas of their operation are operating in sync and in compliance?
So you have to have, when you're dealing with, especially with the hourly employees, and they're not getting their appropriate breaks or whatever it is, the overtime, you really need to have a very solid timekeeping system, right? That is first and foremost. Whether it's an electronic system, whether they're clocking in, they're clocking out, type of thing, or they're filling out timesheets and declaring, hey, I took my meal breaks, I took my lunch breaks, all of these different things, right? That's number one, because if you show that they missed a meal, or if you show that they have overtime, you catch it, you pay it, right? You pay it in the system right there. There's such things as meal break waivers where people can do that. But if someone's working through their lunch, hey, I got to work through my lunch today, make sure you're getting the waiver, right? Make sure you're paying that individual for the time that they work through it, because it's okay, if there's, well, I'm not going to say it's okay, but sometimes things happen where a meal break is missed, or a rest break is missed. But if you as the employer are taking the proactive action to make sure that they're being paid for that and so forth, then that's on your side, as an employer, that's what you have to do. Now, I also tell, employers, like, let's say you have an employee that they just consistently are late to take their meal break, right? Which they're entitled to. And now you have to pay them extra. Write them up for that. And if they continue to have those actions and continue to not comply with your policies, your procedures, and do what they're supposed to do relative to those meal breaks, or maybe it's overtime or whatever it is, write them up, because at that point, it gives you the ammunition later on down the road if you need to terminate that employee for not following the proper protocol and the proper rules, in doing what the employer requires. So, it's good timekeeping system, good payroll system, keeping track of it. And then if what they're doing is against your company policy, make sure that you're writing them up, or you're doing the correction plans and those types of things that can set yourself up if you need to terminate the employee later on down the road for non-compliance.
And for all our listeners, real quick, as we kind of close out this portion of the discussion, if what John just shared with us is not enough for you to act on those new processes, maybe in your business, here's maybe another thing just to note. In the state of California, there are 4 times as many attorneys that have practices focused on supporting the employee as there are attorneys supporting the organization. So that should tell you a lot about the way law works in the state of California.
Where the money is. Well, based on everything you've been sharing with us, John, it sounds like the prudent thing for anybody getting ready to either start a business or maybe buy a business from somebody else is to seek some kind of initial legal counsel that can help them evaluate what is in place or what is expected to be in place, and get a handle on where your exposure might pop up.
You know, you want to review what contracts, what agreements you have. Do you have the appropriate policies and procedures? You know, do you have employees? All of the different things, and are those processes set up? You know, if it doesn't have an HR department, you know, a lot of small businesses, you can't afford an HR department, right? But paying that money to an HR consultant to come through and make sure your payroll's right, make sure that your, you know, how that process is working as well, you know, have them come through as well. You know, I do it on my end, but I'm probably more expensive than an HR manager to come through. And I refer people out to HR managers, you know, all the time and say, hey, look, you know, talk to these individuals, have them go through your records, have them, you know, look at your payroll, those types of things, to make sure that you're compliant. And if you're not, fix it and then do your back pay or whatever it may be so that you become compliant. But yeah, it's a process of, you know, if you're buying a business, you're starting a business, you need to make sure that you're compliant with all the things that you need to be, you know, with regard to the state of California and the particular laws and so forth.
Cool. Well, listen, John, thank you a lot for being on with us today, because a lot of times we kind of, in our normal conversations about, you know, business dilemmas, we tend to bump into some of these other, you know, professional areas that neither he or I have licenses in. So we have to be careful about, you know, what we actually tell people. So it's kind of nice to have somebody of your caliber on today to kind of fill in those gaps and give people some sage counsel about what they should be thinking about doing. So thank you for being on with us today.
Absolutely. And if I could leave people, if they remember one thing from this, I tell everybody, document. Yeah. Have your documents, have everything in writing, have your contracts, have your employee write-ups, have your policies and procedures, have all that stuff in writing, have all your agreements. And, you know, I've told people for years, you know, if whatever it is, if you have the documents to back up your stuff, you're in a much better spot.
Great. All right, folks, listen, thanks for being with us today. We, as always, we come out with brand new episodes every Tuesday at 4 p.m. Pacific Standard Time. So be around next week for another great episode. And again, John, thanks for being with us today. And hopefully if we run into some other really top quality specialists that have to do with business dynamics, we'll have them on for you soon. So take care. Enjoy your weekend. Talk to you soon.